Hi all, welcome to the A-Level Law Essay channel. This is a specially requested episode by one of the viewers. In this episode, the essay is going to be covering the chapter Negligence in the Tort Law syllabus, and more specifically regarding breach, causation, and Novus Actus Interveniens. Before we begin, please subscribe to my channel for more video guides on essay writing and many other interesting topics. And if you are a subscriber and regular viewer of my videos, thank you. I would appreciate it if you do like and share my videos with your friends so that they can benefit from my remote guidance as well. Thanks. With that said, let's get started with part 2, essay sample of video tutorial number 10. Question. The question reads, Alan was employed by Barry's Construction Company Limited. His job involves handling a lot of chemical substances, and he usually does so without wearing any safety gloves as his employer doesn't provide them to their workers. One day, whilst unloading a barrel of hot substance from a lorry, some of it spilled onto his hands and it burned his skin away. In agony, he was immediately taken to a nearby hospital in an ambulance. There, he was examined by a doctor on duty who, after a quick diagnosis, applied some ointment onto his burnt flesh. After that, Alan was given painkillers and left to await further attention. Unbeknownst to any of the hospital staff, the painkillers had a violent effect on him due to the ointment applied to his hands, and because of this, his hands had to be amputated to save his life. Alan now wishes to sue for compensation for losing both his hands. Advise him as to the potential liability of both his employer and the hospital. To answer a scenario-based problem question, it is important to first identify the relevant parties and the issues that they are having with each other. From the scenario, we know that the disputing parties are Alan against Barry's Construction Company Limited and the nearby hospital. Alan works for Barry's, and because he wasn't provided with safety gloves and due to some assumed mishandling of hot substances, Alan's hands were burnt. After being taken to the hospital for treatment, another apparent misfortune befell Alan again and he was medically mistreated, and so he ended up with both his hands amputated. Now we are to advise Alan, who intends to sue both his employer and the hospital. After identifying these important things, we should then be able to figure out which chapter in the Tort Law syllabus this question is covering. By the looks of some of the key points in the scenario, it is safe to say that it covers the chapter Negligence and that it focuses on the topic breach and causation, as we have to determine if either the employer or the hospital have breached their duties of care and caused the eventual damage. Before I begin going through the essay, I would like you to note that my answer is not the perfect essay answer, but it only serves as a guide for you so that you get an idea on how to write your essay and score the highest mark possible for your effort. Incidentally, I may have also left out certain minor details from my content video, as whatever points that have been discussed earlier only serves as a guide for us to reach our end product, which is the essay. One more important thing to note is that since, for examination purposes, the time limit for one essay answer is exactly 30 minutes, I will not have a lot of time to cover every single relevant detail, and the ideal word count for an excellent essay answer is between 700 to 900 words per essay. Introduction. Negligence essentially means recklessness in the conduct of everyday activities, and as it can cause harm to people, it is considered as a civil wrong under tort law. Based on the scenario, we are to advise Alan on who is potentially liable for his injury. To do this, we will have to establish if either Barry's Construction Company Limited or the hospital is negligent under the requirements of general negligence. Point 1. Body paragraph 1. General negligence requires that four main elements be satisfied, i.e., duty of care, breach, damage, and the cause of the damage. These elements must be satisfied in sequence, otherwise negligence cannot be established. Duty of care requires that everyone exercise their civil duty not to be careless in their daily activities. Modern duty of care is determined by the case of Caparo v. Dickman 1990, where three tests must be satisfied. These are the principle of reasonable foreseeability under Donoghue v. Stevenson 1932, the test of proximity under Muirhead v. Industrial Tank Specialties 1985, and what it means by justice and reasonableness to impose a duty of care. Point 1. Body paragraph 2. Based on the scenario, we can assume that these tests are satisfied as Alan is under the care and responsibility of both Barry's and the hospital as the employer and the medical caregiver. This means that, as according to Watson v. British Boxing Board of Control 2001, both parties have a measure of control over and responsibility for the potentially dangerous situation arising from the activity. Point 2. Body paragraph 3. The breach of duty of care is seen as the defendant falling below the reasonable standard of behavior expected in someone undertaking the activity concerned. This standard is, as Nettleship v. Weston 1971 and Simmons v. Isle of Wight Council 2003, is viewed objectively and reasonably. Regarding Barry's case, can we say that by not providing safety gloves to Alan, is reasonable care taken in conducting the relevant activity? To determine this, we will also have to consider the size and the practicality of protection against that risk of injury and common practice in the particular activity. Based on cases like Bolton v. Stone 1951, defendants are not expected to take extreme precautions against very slight risk, and an enormous precaution may be out of proportion in some circumstances. Point 2. Body paragraph 4. However, applying this to the scenario, we can conclude that providing safety gloves to workers handling chemical substances isn't particularly extreme against the risk of injury. Moreover, Barry's also cannot argue that the non-provision of safety gloves is a common practice in the industry that it is in, as cases like Thompson v. Smith Ship Repairers Limited 1984 have shown that companies whose industrial practices show serious disregard for workers' health and safety would not evade liability simply by showing that their approach was common practice in the relevant industry. Therefore, here Barry's has definitely breached its duty of care towards Alan. Point 3. Body paragraph 5. As against the hospital, its special characteristics is relevant to determine the standard of care required in the medical practice. The case of Vowlers v. Evans 2003 states that people with special skills and professionalism require the degree of care taken to be on par with his grade and the situation that he is in. To determine this, the Bolam-Bolito test regarding the standard of practice must be satisfied. In Bolam v. Frian Barnett Hospital Management Committee 1957, it states that so long as a doctor could find a medical expert prepared to state that the actions complained of were according to the standards approved by a responsible body of medical opinion, the doctor's action will not be negligent. However, the case of Bolito v. City and Hackney Health Authority 1997 states that it must also be satisfied that the medical expert's opinion was reasonable. Point 3. Body paragraph 6. We are not sure what exactly transpired, but cases like Holt v. H 2006 has shown that if the condition suffered was unusual and novel, misdiagnosis did not mean that the doctor had fallen below the expected standard of care of his profession. Therefore, with this argument, it is possible to say that the hospital isn't liable for the amputated hands. Point 4. Body paragraph 7. The next issue to consider is who caused the eventual damage. The legal principle under Barnett v. Chelsea and Kensington Hospital Management Committee 1968 states that the cause of damage must be a cause in fact. However, Baker v. Blobey 1969 shows that if a new intervening event occurs, making the original damage worse, the chain of causation is said to have broken, and so the original defendant will only be liable for such damage as occurred up to the intervening event. Looking at how the eventual damage was an unexpected result of the mistreatment, it is possible to say that Barry's liability should stop at the burnt hands and not their eventual amputation. Conclusion. After considering all the above points, Alan is advised that the only possible person whom he can claim compensation from is his employer, and they are only liable to the point when the mistreatment occurred in the hospital. The medical service is generally immune from civil claim unless gross negligence can be established. That is the end of the essay sample for this video tutorial. If you have any questions or opinion on my approach to answering the question, please do comment below. Do check out part 1 of this video tutorial for a proper content guide on how to answer this question. I will put a link to it in the description below. If you find this video tutorial useful, please like, share and subscribe to my channel for more. Thank you for watching, and I'll see you again next time.